Thank you everyone for coming. I'm just going to really briefly say a couple of words. I'm Karen Wong. I'm the Executive Director of the Epstein Program in Public Interest Law and Policy here at the law school. And I know we have an audience of mostly folks from the law school, law students, law faculty and staff, but I know that there were a handful of folks from elsewhere on campus as alums, so I just want to make sure we properly introduce us and the program, the Public Interest Program that is sponsoring the talk today. And I also want to make one housekeeping note before I turn it over to our dean to formally welcome everyone and introduce our speaker. And the housekeeping note is that if you have questions for our speaker, we are doing it with note cards, so if you think of questions, please write it down. Towards the end of her talk, my colleague Brenda Kim from the Public Interest Office will collect your card, so you can hold it up for her to pick it up, and that way we can hopefully have an efficient kind of way of asking questions. We find that a lot of people have similar questions or questions fall into groups, so we thought this is a good way to help our speakers deal with questions. So with that, I just want to very super briefly introduce our dean of the law school, Jennifer Minukin. She is both the dean of UCLA School of Law and also the David G. Prize and Dallas G. Prize Professor of Law. So she teaches here as well. And we really want to thank the dean for her support of the Epstein Program and for the public interest programs here. So without further ado, the dean.
My job here is to do two things. The first, welcome all of you here, and then also to welcome our fabulous speaker today, who's also here as a Margaret Levy Fellow, Vanita Gupta. And it's really terrific to have you here. So thank you for taking the time out of your busy and impressive schedule to spend some time with us here at UCLA. I know it's been a bit of a whirlwind 2 days. I hope we're keeping you very, very busy. That's what we want to do, so that you can share, so that our community and our students can learn from you as much as possible when you're here visiting. And it's really terrific to have you here. Vanita has a long and extremely impressive history in civil rights work on the front lines and at the highest levels. She's president and CEO of the Leadership Conference on Civil and Human Rights in Washington, D.C. And she leads a coalition of 200 civil rights and human rights groups who fight in the major nation's capital and in Congress for vulnerable communities and populations among us. Now, before that, she served as the Principal Deputy Assistant Attorney General, heading the U.S. Department of Justice's Civil Rights Division in the Obama administration. She was the top civil rights prosecutor, notably holding police departments accountable in places like Ferguson, Missouri, and making progress on transgender rights and in fighting voter suppression. Her career has been at the intersection of criminal justice and racial justice, and she's also held distinguished positions at the ACLU and at the NAACP's Legal Defense and Education Fund. And she's tackled issues like wrongful convictions, mass incarceration, and immigrant detention. So it's not too much to say that, pick a hot button issue that we're thinking about these days, and Vanita has engaged with it meaningfully and worked to make a difference. And so we are truly extremely fortunate to have her with us this semester as our spring 2019 Margaret Levy Public Interest Fellow. This is a new program for us this year, the Margaret Levy Fellowships, and the idea is to bring incredible people like Vanita here to the law school and have them spend a couple of days engaging with our community. So it goes beyond just a talk like this and provides a deeper and richer chance to learn from, engage, and think about our own, our students and their future and their careers, and to create mentoring and networking possibilities, as well as just in a way thinking about the public interest imagination, what's possible out there. And so it's incredible to have you with us in this inaugural year. I'm sorry that Maggie Levy isn't here with us today herself, but I do want to just publicly recognize and thank her for the generosity that has made this fellowship program possible and has let us inaugurate it this year. So without further ado, if you don't want to hear from me, let's hear from Vanita.
Let's see, do I need to turn this on?
No.
It's on. Okay. Thank you all, Dean, for that super generous introduction. Actually, it's been great to be here at UCLA Law School because I feel like I've run into so many old friends who are now faculty members. So you guys as law students should look around because there are going to be members of this room that will be serving as law faculty later on, but it's been really great for me to reacquaint myself. And I also have two of my former DOJ colleagues who are now UCLA law students, John and Cheryl in the back row over there, and Cheryl was with me also at the Leadership Conference. So it's like a reunion for me of sorts. But good afternoon, and it really is an incredible honor to be here today. And I want to begin by thanking Karen, who's done yeoman's work in doing the schedule. You sat there keeping me really busy, but it's important for me to be able to speak to students about public interest careers and how meaningful these careers can be. And I also want to thank the David J. Epstein Program in Public Interest, Law and Policy, and really the entire UCLA Law School community for hosting me on campus this week. I'm really grateful to have this time with all of you as we work to make our nation more fair and equitable. Roughly about a half a century ago, the promise of opportunity led my parents to emigrate from India to the United States. And my father came to the United States on a scholarship to get his master's degree. But as a precondition, my grandmother said he had to get married before he left. And so just days, actually it was like 3 days before he left India, he married my mother, whom he barely knew, but here we are 50 years later. And some of you may have a familiar story, that story may sound familiar to you, but their story really, to me, is a remarkable one. From confronting the cold snow and ice in Ithaca, New York, where my father was getting his master's degree in the late 1960s, to my mother learning English in her 20s, and to my parents then learning fluent French in their 40s, to raising two rather firebrand daughters. They have, in a lot of ways, modeled the resiliency of immigrants in America. And I often get asked about what motivated me to become a civil rights lawyer. And I have a lot of different experiences, notably the experience of my parents and their immigration story, but also because we were moving around a lot. And when I was 4 years old, my family moved to England, and one day I was sitting at a McDonald's in London with my sister and mother and grandmother. We had just picked up my grandmother from the airport, and as we ate our meals, a group of skinheads at the table next to us began to shout ethnic slurs at us and started throwing french fries at us until we left the restaurant. And I don't remember much about my life as a 4-year-old, but I do remember that day and the incredible and acute embarrassment that I felt leaving the restaurant. And I tell that story because the experience stuck with me, because it's my first and earliest memory of being kind of acknowledging difference and being different in a place. And I often then would later enter rooms and institutions and kind of note who else looked like me or who else kind of fit in and what the makeup of a room was. And despite our experiences with prejudice, my parents really maintained their belief in the inherent promise of fairness and in the promise of America. From them, I learned that patriotism is synonymous with public service, and to love this country really means that we see its flaws, but that we commit to making it better. And that conviction has fueled my own journey, both career and personal. And there really was only one path calling me, and that was to be a civil rights lawyer. My first job out of law school took me to the small panhandle town of Tulia, Texas. I was a 26-year-old law school fellow funded by the Soros Foundation at the NAACP Legal Defense and Educational Fund, with little experience to speak of except for the clinics. And so for any of you interested in public interest law, I would urge you to take clinics. But that was literally the legal experience that I had when I began working on a set of troubling cases in Texas. I'm going to tell you a little bit about the story of these cases because they really shaped who I have been and the work that I've been doing, but that so many are doing right now around the country. On July 23rd, 1999, over 12% of Tulia's adult black population had been arrested for low-level drug offenses. 46 people, 40 of whom were black, 6 of whom were Latino or white and in romantic relationships with African Americans in the town. And the arrest took place at a pre-dawn raid by a team of police officers who were dressed in head-to-toe in SWAT gear. And local papers then, hours later, after the arrest had taken place and people had been paraded into the local jail, followed by local TV cameras, the local paper ran a headline that said, "Tulia streets cleared of garbage," and printed the names of the men and women and their addresses of the folks who had been arrested. And because of the false testimony of a single police officer, the first 7 people charged opted for trials and swiftly received sentences of between 20 and 361 years was at the back end of that. This was all for very low-level drug crimes. In some cases, multiple counts, but all for low levels, between 1 and 4 grams of powder cocaine. And in the face of these odds, the remaining defendants made the decision that I would make, the very rational decision to take plea deals. And I remember driving for hours and hours on the flat highways in Texas, going from prison to prison, because at this point, people were spread out in jails and prisons across the state. I was staying up feverishly to meet deadlines in cases, trying to count the days that people had before they would be unable to go back into court. I was totally in over my head, and I remember feeling fairly panicked about it. Now, remember, I was down investigating these cases. The sting happened in 1999, and I made my first trip down to Tulia in 2001. It was just weeks after the 9/11 attacks. And at that time, people who looked like me were being regarded with suspicion around the country, and I kept my guard up, even though, there were a lot of people in West Texas who had never met a South Asian person. And I know John and Cheryl have heard me say this a lot, but it still happens to me now, but everywhere I went in West Texas, people were asking me whether I was related to Dr. Sanjay Gupta, because it was the one South Asian person that folks actually knew back in 2001 in West Texas. And I've never yet had the chance to meet him, and one day I will thank him for opening doors for me to the family there. But I eventually assembled a really formidable team of lawyers to work with. These were lawyers who, I just couldn't do this on my own. At that time, LDF had 3 lawyers working on criminal justice reform, all of whom were focused on the death penalty. And I will say, and I talk about this because I think it's important to remember, that as recently as just 15 to 16 years ago, civil rights organizations and a lot of progressive organizations were frankly asleep at the switch around what was happening in mass incarceration and in our nation's criminal justice system. There's a lot to be said about the story and what happened in Tulia, and I'm not going to do that here today. There was a great book that local investigative reporter wrote by the name of Nate Blakesley about the cases. But by 2003, after a couple of years of really hard litigation and media work to expose what had happened, we had shown that the so-called drug sting had in fact been a really grave injustice. And as a result of our work then, Governor Rick Perry pardoned the Tulia defendants. But I tell this story really, and there are many, many more stories like it. I tell this story because I learned personally a few really important lessons that continue to serve me in my legal career. First, it's really important to know why you're doing something and to know your purpose. I think it's going to make your career more fulfilling, and it will be your lifeboat when times get tough. This work is not easy. There are a lot of days where you struggle, where it's uphill. But while working on the Tulia cases, there were many, many days where I doubted myself. I felt overwhelmed. And it was really, frankly, being in touch and in conversation with the clients and their families to see what they were going through that pushed me forward. And I kept going because I believed, and I really still believe, that the law is one of our greatest tools to right the wrongs of our justice system. The second lesson I learned, which is serving me really well right now, is that despair is the enemy of justice. When I arrived in Tulia, I couldn't have possibly imagined the capacity for hope that I saw in my clients and in their families. They really showed me the courage of their convictions, of fighting against all odds. Imagine this is West Texas, it's 1999, 2000, 2001, where the state of Texas was investing more in building prisons than it was in as California was then in higher education at the time. But these families really showed me what it means to cultivate courage in the face of these insurmountable odds. And they knew something that I hope that each of you will remember today, which is that the story of America has been a story of hope. And the story of civil rights lawyering and public interest lawyering is a story of hope. It's a story of determination. It's a story of persistence against all odds. As I said, this work has never been easy. But it's also a story of what can happen when we imagine a different future. And these days I've been invoking what Nelson Mandela said, which is that every idea seems crazy until it actually happens. And that's something that I think we need to remember as we kind of think about what our North Star is as we do this work. And lastly, I think it's really important not to run from discomfort. There's one particular night that I remember when I was litigating these cases, and I couldn't sleep because I was really convinced that I'd missed a court deadline because of my inability, frankly, to do basic math. And I was like counting the days. In Texas, you have 365 days from the date that a person loses their appeal to be able to file a habeas petition. People have been put to death in the state of Texas for missing this deadline. So I was sitting here literally counting the days on the calendar, and in the middle of my meltdown realized I actually had one more day to file. And in that moment, I kind of asked myself, why did I do this? Why was I? It was in over my head. I didn't have help. Why did I agree to take this on? And I will tell you, though, that the most meaningful things that I've ever done in my life have taken me out of my comfort zone. They have forced me to geographic locations that I didn't think I was going to be in. They have forced me to put myself in situations that I didn't think were going to be easy, and there were the path of resistance where there were obstructions and I needed to get through it. But I have learned that in those moments is really when you can express and demonstrate the greatest leadership and courage that can make the greatest difference. And in 2014, I was given the tremendous honor of leading the Justice Department Civil Rights Division for President Obama. And I have to say it was pretty unexpected, because for somebody who has spent her life suing the government, to now be asked to join the government was a very different role. And I think it was a testament in a lot of ways to the Attorney General and the President at the time that they wanted to take an ACLU LDF lawyer and put her at the helm of this organization, of this component at the Justice Department. But I began my tenure just weeks after Michael Brown had been killed in the streets of Ferguson by a police officer. And the movement for Black Lives was really forcing a very necessary conversation about the role of law enforcement in communities, about public safety, about justice. And at the time that we were in, the Justice Department was really kind of seizing the momentum to drive progress on a range of issues, from policing to debtors' prisons to access to counsel. We were doing what we could to end the nation's addiction to incarceration. And from LGBTQ rights to human trafficking, fair housing, voting rights, we were trying to answer the call to make the promise of justice real for every person in America. And so you can imagine what the state of affairs was in November of 2016, and it then followed by a pretty acute sense of whiplash that has continued to this day, as we have an administration in Washington that openly abdicates its responsibility to enforce civil rights and equal protection. But really make no mistake, because in a lot of ways, what I'm also deeply energized is the amazing groundswell of organizing and activism that is taking hold in our country right now. And the reality is that we are fighting these fights as a massive collective, folks who never saw themselves as activists rising to the challenge today and expressing their activism in a whole slew of different ways around the country. It was almost 2 years ago, just under 2 years, that I took the helm of the Leadership Conference on Civil and Human Rights. Our coalition's founders, a cross-section of African American, Jewish, and labor leaders, believed that the fight for civil rights couldn't be won by one group alone, but would need to be waged in coalition. And the Leadership Conference was founded in 1950. It was a time of unrestrained racism and dreams deferred. And to be a person of color in America was to experience daily the indignity and humiliation by public officials and private citizens. But our founders came together in that time not because of terror and tragedy, which also existed in this backdrop, but they really came together in spite of it. And they created our coalition not out of common fear, but with common purpose, which was to fight for equality for all. And the common purpose sustained the coalition through the 14 very difficult years that it took to pass the most ambitious civil rights legislation that has ever passed in this country today, the Civil Rights Act of 1964, and the Voting Rights Act the following year. That common purpose gave our leaders the wisdom to see that civil rights are women's rights, our LGBTQ rights, our immigrants' rights, our workers' rights, our disability rights, and our human rights. And that common purpose is truly our inheritance as we do this work today. It's a living legacy that binds us together in cause and community. And in spite of the really deeply challenging days that we're in right now, I say over and over again that we have to choose love and act out of love instead of bitterness, and faith instead of surrender. We've got to be able to see possibility through pain, and as our coalition's founders knew, and as my own parents taught me many years ago, the enduring belief of a more perfect union really fuels our fight for a fairer and freer America. And it always has. But I don't want to mince words about what we're facing today. Our democracy is gravely in peril. We have a president who relentlessly attacks the free press, the judiciary, the Department of Justice. We have a president who declares a national emergency over a racist vanity project at the border, even while admitting that he, quote, didn't need to do this. His administration's shameless undermining of our democracy should concern all of us. Last week, some of you may have been following what was happening in North Carolina, where North Carolina State Board of Elections ordered a new election in the 9th Congressional District after a political operative for the Republican candidate had literally been illegally harvesting ballots and illegally tampering with absentee ballots. And the great irony here, of course, is crickets from the president and those who've been falsely decrying the so-called myth of voter fraud to pass and shrink the electorate rather than seeking to allow everyone who's eligible to vote to vote. In headline after headline, we are reading about reports of barriers to voting. Long lines in majority black neighborhoods. It's antiquated and broken down machines. In 2016, 10% of Philadelphia's voting machines broke down, and we know which voters that impacted. Problems with voter registrations and provisional ballots, voter purging done in the so-called name of voter roll list maintenance, targeted and deliberate misinformation on social media around voting procedures and election procedures. And as problems escalated, even as recently as the midterm elections, the solutions and accountability really often never came. But to understand the landscape today, we have to go back to June 25th, 2013, which is when 5 justices on the United States Supreme Court invalidated key provisions of the Voting Rights Act in a case called Shelby County versus Holder. This case gutted and disabled the Justice Department's ability to track all of these small, seemingly race-neutral changes that election officials were making in local election administration around the country, particularly in jurisdictions with long histories of racial discrimination. And within 24 hours of the Supreme Court's decision in the Shelby County case, conservative justices prompted a deluge of anti-voting rights legislation in states around the country. Within hours, North Carolina geared up to pass what became known as the monster voter suppression law, ultimately invalidated by the 4th Circuit Court of Appeals for having saying legislators targeted African Americans with, quote, surgical precision to undermine their right to vote. Nearly 2 million fewer African Americans voted nationwide in the 2016 election than in 2012. Think about that. That's a civic engagement problem as well as a voter suppression problem. And while, again, likely the consequence of a whole bunch of factors, perhaps the most striking is this, which is that 2016 marked the first general election since the Shelby County decision took effect. And the erosion of voting rights has only accelerated in the Trump administration. The president has aggressively worked to undercut the power of communities of color, particularly African Americans, immigrants, and other groups historically excluded from our political process. And in the absence of voting rights and a robust Voting Rights Act, Republicans, unfortunately, we're in a time where civil rights has become so partisan in a way that it never was before. It's incredibly dangerous for our country. But we have a party now that is weaponizing the law to chip away at voting rights under the banner of so-called election integrity. And no amount of spin can disguise the tactics from what they are. These are truly dog whistle policies designed to silence targeted groups of voters and ultimately to shrink the electorate to preserve a certain base of power. And that's why the Leadership Conference and a group of leading civil rights organizations created a campaign called All Voting is Local to help ensure the right and ability to vote are protected. A lot of times litigation happens after people have already been disenfranchised and elections have taken place. But this campaign works with election officials and with historically disenfranchised communities through data-driven organizing, strategic communications, and partnerships to identify and remedy barriers to the ballot box. Because we have to be clear about this, which is that voting and the ability to participate in our democracy, it's a racial justice issue, it's a civil rights issue, and we are long overdue for change. And right now in Congress, there's an omnibus bill called H.R. 1 that will pass the House of Representatives, won't go through to the Senate, but really represents the North Star of a robust democracy reform agenda that I think is so important that we kind of work towards its passage over the long term. But threats to a fair and just democracy also extend beyond elections. Trump is swiftly remaking the federal courts with hardline extremist judges. He hasn't nominated a single African American woman to the federal bench, nor any African Americans or Latinos to the circuit courts, and yet he has, he has 25% of all judges in the circuit courts are now Trump-confirmed judges. We have now moved the needle so much that we have nominees unwilling to say in the Senate Judiciary Committee hearings that Brown versus Board of Education was correctly decided. Even Justice Gorsuch at the start of the administration, when he was confirmed, said that Brown versus Board of Education was correctly decided. But the needle has been moving so much that now we're in this place. And our coalition and the civil rights movement broadly have led an unprecedented mobilization to save and protect the federal courts and their independence. We're moving civil and human rights to the center of the conversation and activating a national constituency that needs to be more concerned about what's happening to our courts. We don't have the kind of voters that others do. When Roy Moore was running for the U.S. Senate, voters in Alabama said, we don't like Roy Moore, but we care about the Supreme Court. We did not have voters coming out to center the courts, progressive civil rights voters coming out to really make the courts a priority in that same way. And meanwhile, at the Commerce Department, Secretary Wilbur Ross, at the bidding of anti-immigrant extremists, including Steve Bannon, has proposed the addition of a citizenship question to the 2020 census. And this question, the fact that this question is going to be on the form unless the Supreme Court, which is now going to consider the case in April, we know that it will lower response rates and lead to an inaccurate count. There's already such intense levels of fear in immigrant and mixed status families. And so this is a very, very big deal. And while the issue moves through the court, the Leadership Conference is working to ensure that Congress is going to have avenues to remove the question, even as we coordinate the amicus strategy. We are also working in 30 states, and I would urge all of you to get involved as organizers. The Census Bureau is going to be hiring 500,000 enumerators that need to be people rooted in local communities that look like the folks that need to be counted in those communities, to become organizers and to make sure that people will get themselves counted and be a part of the census count, because the census will determine political apportionment in the House of Representatives. It will determine redistricting for state power in the state legislatures for 10 years, and will be the basis for $800 billion of federal money allocated to schools and healthcare and the like. And there's nothing that Steve Bannon wants more than a systematic undercount of the hardest to count communities in order to really rewrite how political power is distributed in this country. So the current moment really calls on us to recognize that democracy is, and the preservation of our democracy is a fundamental civil rights struggle right now. And as we face a federal government that is increasingly receded from the job of protecting civil rights and the most vulnerable among us, more than ever, it falls on all of us to defend our fragile progress and fight for a fair and safe and inclusive nation. And so as many of you prepare to launch your legal careers, I just want to say a couple of things in closing. One is to ask that you keep an open and curious mind. Public interest law is really a profession of possibility. It's a profession of honor. It's a profession that at its very best reflects we the people. And in America, we use the law to transform values and ideals, among them fairness, inclusion, and justice, into real protections for people in this country. We know that throughout our history, the law has not lived up to its ideals, from codifying slavery and Jim Crow to denying women agency over our own bodies and lives, to forcing LGBTQ Americans to hide who they are or risk arrest. But really the beauty of the story and the role that public interest lawyering has played in really helping to move this country in the right direction, it's lawyers that have been at the front lines, oftentimes working in communities to close the gap between our constitutional guarantees and the real experiences in communities. And so this work has never been easy, and change doesn't happen overnight, and nor is it inevitable. Within hours of the president's announcement of the Muslim ban, it was lawyers and law students who rushed to the airports around the country, not because they were Muslim, but because they cared about the values of this country. These were lawyers and law students of all backgrounds that were seeking to help and understood that their degrees conferred special power and a unique responsibility to do this work. We also saw the same mobilization at one of the greatest horrors of our time, involving immigrant children being taken away from their parents at the southern border in May and June. This is not a crisis that is over. In the face, though, of horrific inhumanity of what that has meant for families, it was lawyers and activists and faith leaders and grassroots activists and just people who cared that came out and did the protests, that were filing the lawsuits, that were trying to do whatever they could and that we could to be able to protect and hold families together and kind of protect what we think are American ideals. And so we don't have all of the answers even months later, and we still have congressional oversight hearings where heads of agencies are saying that they don't actually still to this day know how many kids remain in our nation's detention facilities with no access to their parents and families. And so we have to fight on because we must. But in November, we finally got checks and balances restored to Washington. And there were voters that came out in droves, civil rights voters, voting for democracy reform across the country. One thing that is so vivid to me is in Florida, with Amendment 4, the amendment to restore voting rights to people with felony convictions, there were weeks when dreamers were out knocking on doors to restore the right to vote for people with felony convictions. Now, to me, I'm like dreamers who actually don't have status, who can't vote in our elections, showing up to do what they could to save our democracy. And in those instances, I feel like if any of us are sitting around complaining about what is it that we can do, we can't make a difference, just take a look at what they were doing back in October and November, and let us all be humbled and called to action because of that. But especially in times like this, it is important to remember that we're not always going to get the outcome that we want. And the decisions made in our nation's highest office might defy morality and decency. But you've got to reject cynicism and always believe in the value in the struggle, because you are the next generation of lawyers, soon-to-be lawyers, that will be called on to fight for equal justice. And a commitment to justice is really, truly the prerequisite for continuing our progress and fighting through struggle and building the kind of America that we know we can have. So we're counting on you, I'm counting on you, and we really do, in some ways now more than ever, need you in the fight. So thank you.
So if you have questions, please write them down or hold them up for Brenda to come around and collect. But I'll start with a couple. So one thing, and I've had the luxury and benefit of having been in several conversations with Vanita over the last less than 24 hours. But you have talked a lot about how the leadership conference and, well, your background wasn't necessarily voting, but the issue of voting and democratic institutions in our democracy has been very core to how your organization is looking at civil rights. And so it'd be great to hear from you as a thought leader on this. What do you think, all of us as law schools and as law students can be doing, should be doing with respect to voting and elections? Because I think many of us are mired in our passion issues like criminal justice and immigration and homelessness, but I hear you saying that voting and elections actually, kind of cuts across all of these issues.
Yeah, I mean, all of these issues are deeply important, and we need people to be focusing on them. I think that the thread of democracy and voting rights is the right that kind of undergirds all other rights. And so I do think that even at law schools, I was speaking with my friend who was my deputy in at the Civil Rights Division, Justin Levitt, earlier, who was telling me that Loyola actually declared a day of public service on the election day, and all law students were encouraged to become poll workers, nonpartisan, to become poll workers, and to make sure that there was, they were modeling the kind of commitment to voting rights that we want the country ultimately to have. And so I think, it would be great, and the dean just left, unfortunately, so she didn't hear me say that. So you guys can convey the message. But, that's the kind of thing where we all have a role to play in this. And I would say become a census enumerator. It's a short-term, temporary thing, but if you have any interest in organizing and in helping to do this work and to make sure that there's a fair and accurate count, in communities that are living in fear right now of reporting anything to the federal government, become an organizer that way to do this work. There's any number of ways for folks to plug in, even outside of being a part of a clinic, to do this work. And I'm a great supporter, as I said, of the clinics, because I think that it presents a really important opportunity to get on, concrete experience with clients. But again, there are so many ways to get invested in this work.
Thank you. So we do have some questions, and I'm going to piggyback on that last one because there's another one around voting that was asked. So first of all, I think this person is speaking for many people when they say thank you for being such an inspiration. But then the question is, what do you think about requiring all jurisdictions to be subject to DOJ pre-clearance? Is that a way around Shelby County?
So there's been a lot yesterday, both in the House and in the Senate. Senator Leahy and Representative Terry Sewell introduced the Voting Rights Amendments Act, and the reality is it'll pass the House of Representatives like everything else and won't pass the Senate at this moment. But there's a lot of talk about what the formula should be. When the Supreme Court gutted sections 4 and 5 of the Voting Rights Act, what it was that they were doing was they were gutting the formula that had been established in 1965 but reauthorized periodically, the last 3 times actually, in a Republican administration, reauthorized with almost unanimous support as recently as 2006, around states that had long histories of racial discrimination or particular jurisdictions that had histories of discrimination, and making clear that election officials needed to clear changes in local elections by the Justice Department. And so I don't know that it would work to put the whole country under pre-clearance. There's been a lot of thought in a formula. We can get into detail around, right now it's around 11 states and other jurisdictions that have been, violated, 10 documented violations in this area. I think that remains to be debated. Section 2 is still a part of the Voting Rights Act, and that allows for after-the-fact litigation to be filed. That litigation is the kind that you saw challenging the North Carolina law, Texas law. It takes years. It's very expensive, and it takes years. But the pre-clearance regime is really important, and frankly, I think it would be great for law students and professors to think about what the formula should be. There's in the bills that are pending right now, it is around the jurisdictions that have been found to have been violated, have had findings of racial discrimination in voting 10 times in the last 5 years.
So taking some questions that expand out from the voting issue. So I think this is interesting. So what does the inclusion of a human rights frame in your struggle for justice and equality add in the U.S. context? And I think the Leadership Conference expanded from Leadership Conference for Civil Rights to Leadership Conference for Human Rights at one point.
So civil rights are rights that are conferred by the legislature and then validated by the courts. And the notion of human rights is that we have inalienable rights to dignity and to the slew of human rights that are embodied in the Declaration in human rights documents and treaties. And so I think what it does is really help center our work around core principles across communities and in a more kind of global environment. We don't do work outside of the United States in terms of our work is domestic and focused on domestic issues, but we do seek to go vindicate these rights in international bodies that use a slightly broader framework to do this work. And I think it sometimes can help us reframe our civil rights work domestically to have this kind of broader analysis. I will say right now, there's been such a cutback on kind of the human rights framework and such an assault coming from our government that our human rights work, I feel like we've been looking to make sure that we're introducing and keeping a human rights framework in all of our civil rights work. But it is a challenge right now as we're kind of doing, it's an all hands on deck moment. But it was a very intentional decision to kind of make sure that we were grounding the broad civil rights movement in the human rights framework, just like Martin Luther King did.
Did that change who was in the coalition?
It didn't. I think the one thing is that it allows us to focus more squarely on economic rights as well, and because that's more kind of inherent to a human rights framework. But it didn't. I think it like Human Rights Watch has become a member. That's true that there are some organizations that before were not members of the leadership conference that today are, that are doing a lot of like much more human rights work.
So a question about, well, I'll just read the question. How might the work at the lower levels where many of our students or recently graduated folks might be at look different when there's an administration that is more sympathetic to the goals of many of the public interest-minded folks here versus a situation that's less favorable like now?
Yeah, I mean, I think right now there's so many great places doing work. A lot of it is it's nonprofit organizations, it's states attorneys general offices. That, I mean, we've got a really fantastic office here in California that is doing some of the most groundbreaking work, and they're kind of rising to the challenge to fill the void in a particular way. And I think it's really important to recognize that, as I said, in the face of a federal government that's abdicated this responsibility to do that work. But a lot of what we're seeing right now in Washington and a lot of nonprofits is highly defensive. But we aren't going to win over the long term if there isn't an affirmative agenda. We aren't articulating affirmative principles. And that's where I think bills like HR 1, which really can be North Stars to guide a broader agenda over the long term and not just have us confronting the most recent, racist policy or and the like, I think is really important. It's important to inspire people with bigger ideas, and we're seeing that happening in Congress with the most diverse Congress, a newer crop of lawmakers who are coming in to talk about Green New Deal and Medicare for All and HR 1. I worry that we don't have that for immigration. I think that we need to have something like that that articulates a more kind of moral underpinning for immigration policy. But these are the kinds of things that I think are, then will prepare us for a different Congress when the day comes to actually be able to pursue immediately an agenda that we've built groundwork for. All of the kind of reforms that are in a bill like HR 1 are reforms that have been enacted in states, and California has enacted a lot of them around automatic voter registration and same-day registration, online voting, but also broader things like the restoration of rights to people with felony convictions, dealing with campaign finance, money in politics issues. And so, and the work in a more civil rights friendly administration then becomes about making sure that you've got momentum and movement to be able to enact these things into law. If you look at what happened in the courts in the first years of the Obama administration, people were caught flat-footed, and the administration completely squandered the opportunity to fill vacancies with, constitutionalists, with lawyers who care about civil rights, with public interest lawyers. It's not just prosecutors, but it's a broad spectrum. And that's the kind of thing that we should not ever be caught by again. And advocacy groups have a really important role to play to pressure these groups. The leadership conference used to come in to meet with me when I was head of the civil rights division on a range of issues that they cared about, really to kind of make sure that I was hearing them, that I was aware of what was happening, fact patterns that were happening, situations that were happening that the Justice Department needed to get involved with. And so it looks different in that kind of instance. The leadership conference is not going to the Justice Department in this era. We engage and are doing the work on the outside about the kinds of rollbacks that we're seeing, but that it looks different in that way.
And then just a specific piggyback on the DOJ question, since you were there for a couple of years at the end of the Obama administration. The Department of Justice and Honors Program is a program that many of our graduates have aspired to. A number of our graduates are there, but it's become harder in the last couple of years for our students and our recent graduates to seriously consider, taking that opportunity and your thoughts on, kind of like, should we take a longer term? I mean, assuming you can get it right. I mean, there is the political piece that's way into it's hard, but we've had a lot of students have interviews, have gotten offers, but there's a fear of going in at this moment in time, given like the values the students and the graduates hold versus what they see the government actually doing.
Yeah, so right after the election, we had just actually made our honors offers before the election, and then I actually called every one of the candidates who had received an offer after the election saying, come, like, don't not come because of the election. And I think I had like pretty abysmal success. I think it was like a 50% success rate. I don't know, Cheryl, was it like half of the folks I think ended up still pulling out despite my very, emphatic pleas. Maybe it would have been 0 before, but I really want all of you to continue to seek out to do internships at the Civil Rights Division, to apply to the honors program. The career professional lawyers in the Justice Department are committed to the mission of the Justice Department. And they, despite the fact that some of the highest profile work and the systemic work that has been under attack that Jeff Sessions so efficiently stalled or did away with, yes, that may be eroded, but there is so much phenomenal work still that the lawyers and the staff in the division are doing on individual bread and butter cases, or finding ways to push. If stuff doesn't rise and doesn't have to be too high profile, it's still getting done, and it matters to people around the country. And the honors program is an incredible program. Right now, we haven't seen, I shouldn't wish this, but the politicization of hiring at DOJ the way that we saw in Bush 2. What we are seeing is that as people have been leaving the Civil Rights Division, they're just not filling the positions up. But for law students, for interns, I would really encourage you to still continue to work there. These are folks that are as committed to the cause as ACLU lawyers are, as leadership conference lawyers are, and they benefit from your new energy, and it is still, I think, a really great thing for your career if you were able to get that offer or go. It's a great experience to work on the inside. I've really benefited myself, even as an advocate, from having been both in the inside and the outside, and so I really encourage people to continue to seek out those opportunities.
That's great perspective. A question about the practice of public interest law. So, public interest lawyers are often very driven and committed, to their values and the public interest what they want to do, but that doesn't necessarily make us all qualified to actually, as new attorneys, meet the needs of our clients. Many are traumatized, many have very challenging lives and issues, and so just from your experience, someone who has kind of been, done that work for many years, what do you suggest new attorneys do when they are asked to find cases where they feel unqualified? I think you mentioned, like, you walked in.
Yeah, that was my experience.
Like,
totally unqualified. No, really, I think you have to know when to ask for help, and I think it's really, it's always important to be humble in this work, and your clients will often have had a range of experiences that you've never had, and to recognize, and to be humble about who you are and your position in that relationship. But I also think it's important to ask for help. I mean, one thing that is different, it's both a boon and a curse, is that as public interest lawyers, you're often you're kind of thrown into the fire, and you learn by doing, you learn by making mistakes. When I was doing the Tulia cases fresh out of law school, I was working alongside these very experienced partners at major white shoe law firms, and their first year lawyers were, carrying the boxes, but they were doing so much of the grunt work, and I was taking the deposition. But I was like messing it up, but I learned how to take deposition. Now you have to be careful because you don't want to mess it up for your client, and so I asked for help a lot along the way. And but I also think you have to have a degree of fearlessness as you do this work, and you realize that there's, when I kept going to the prisons and my clients were like, wow, you're my lawyer and you look like you're 14, and I needed to, for my clients, let them know that I had a team, that we were going to be in this together, and I just kept having to show up and prove myself also about my commitment to them and to the cases. And so I think all of that is really important. At places like public defender offices and legal aid offices, my husband's the legal director for the DC Legal Aid Society. There's an incredible, pretty rigorous training program that you don't get at national civil rights organizations and impact organizations. So there's really something to be said for those of you who want to do some work in direct services, you do get really significant trial training in a way that you just don't at impact litigation shops. And I think that can be really, really beneficial. But the great thing about having a law degree is you can go in and out of the public sector and the government into the private sector and kind of get a range of these experiences. But I think it's useful to not feel like also that your first job is going to determine the rest of your career, because that's definitely not true.
So I'm going to ask one last question and then try to give us some time for folks to have one-on-one with Vanita before we have to clear out of the room for the next class. And so the last question is, can you comment on the ways in which you use allies, for example, researchers or academics, to support the legal advocacy work that you're doing?
Yeah, I mean, I think on all of the issues that we work on, we work with academics that are creating, and they're witnesses at the hearings where I may be testifying as an advocate. I'm testifying alongside a professor or professors who are pretty deep experts on a particular issue. We've been working with data scientists on mapping out the hardest to count communities around the country for the census. So we now have a national map literally down to the block of where the hard to count communities are and kind of the extra organizing and communications work that we're going to need to do. We work, in almost all of the work that we do, we are working in coalition, not only kind of in coalition across organizations, but also across sectors, with academics, with folks in the business community, with researchers that are helping to inform criminal justice reform, helping to inform our work on the census and the like. And so we have to be, I think, we won't win if we're just talking to ourselves, and we often are, have new ideas, and innovation comes from those conversations. We've been doing a lot of work recently around the concern around Facebook and Facebook's imprint on both in terms of being a platform that can promote disinformation, misinformation, voter suppression around ad targeting, illegal ad targeting and the like. And the research and tech side has been really invaluable to helping inform kind of those conversations and the advocacy we're doing in that space as well.
Thank you, Vanita.